Thank you very much, Georgina, and thank you very much all the participants who have joined this meeting today. We wanted to keep it interactive. That's why we shared a Zoom invite in which we could participate, especially in the Q&A session. So in first part, we would try to mute ourselves, most of the participants except the speakers, or in this segment myself, and then once we reach the question and answer session, we could, speak on turns or by raising hands or by sending messages to Georgina, and then she would call out the names of the people who could ask questions depending on what is the volume of these questions. So welcome to this webinar. Let me throw a little light on my career and on my practice. I am a barrister and solicitor and immigration and business lawyer in Canada. I practice in the province of Ontario. I have multiple offices in Ontario, and we help business people, individuals, professionals, and family class participants or applicants from all over the world to not only immigrate to Canada, but later on become citizens, successfully establish their careers in business or in professions. Now, I have a YouTube channel as well, and you could, once you Google ourselves, or you would see the links at the end of this presentation, or you could we could send you those later. You could always join. We always keep on introducing smaller videos to introduce the concepts, various concepts of Canadian immigration and how one could secure temporary and permanent residence in Canada. And once you are introduced to the topic, we could always delve deeper into this by holding or scheduling consultation. So one important announcement I'm trying to make, that before we jump into the question and answer session, I would share two links for submitting your information on this website, and later on, Georgina would also be able to share this presentation in a PDF format with you with those two links. So all the participants who wish that we look at their information, their profiles, their preliminary information, including their educational experience, language proficiency, and other credentials, they could always click those links and submit their information on those forms. So once we receive that information, we would look at the forms, your information, and then somebody from my law firm, after I have reviewed your profile, would get back to you with certain proposals or suggestions for you to undertake Canadian immigration route. Now, we are also, we have, Canadian immigration is a pretty complicated subject. It's not as easy as the people abroad show, because most of the times when you are interacting with internationally with the people or the professionals or those people who show themselves or project themselves as immigration professionals, they have no credentials. They have no immigration credentials. They are not bound by the rules of law societies or regulatory authorities in Canada, and then they feel free to advise you on certain things which they are not competent to advise, or which they are not allowed to advise as per Canadian law. So just to keep it in view, and depending on how much interest we have from abroad, we always schedule legal consultations with the people, and that legal consultation and assessment, it costs somewhere from $500 to $1,000. So any serious participants who wish to hold a one-to-one session with us in the form of assessment and legal consultation, in which they could ask questions about their specific situation, we book a consultation, which is a paid consultation with those people. So after the consultation, if they feel that they qualify or they should apply for Canadian immigration through a specific program, we give a credit of that initial amount towards their fee. And if they do not qualify, it's a good idea to spend a few $100s and save your thousands of dollars, which would go in the pockets of unscrupulous so-called consultants. And then you would not be nowhere, you would waste your time and everything. Now, in this presentation, in this meeting, we are offering 3 free consultations to the people. Once you sign up, you send your forms to us. The first 3 forms which we would receive, we would not only assess them free of cost, but we would also do a free consultation, schedule a free consultation with them, with myself or with another professional in my firm. And in that session, they could ask all the questions and we would be able to render legal advice to the people. But all other participants who fill out our forms, preliminary information and client identification form, we promise that we look at your forms and we'll evaluate whether you have a very high chance of immigrating, medium chance, or low chance. And we would also suggest that yes, or at this time you have a lower chance or a low chance of coming to Canada. But if you hire us, there may be certain ways in which we would be able to bump up your scores, or we would be able to maximize your chances of coming to Canada. So that's the basic thing which I wanted to share before I jump into the presentation. Now, today's presentation has an agenda which you could look at and see on this screen. We will talk about, we'll have a general overview of Express Entry, and then we will delve into the second part, which is Federal Skilled Workers class. I've chosen this Federal Skilled Workers class because this would be the most relevant, because I assume most of the people who are joining this, this webinar are already placed internationally. They are not inside Canada. They do not have any Canadian experience or Canadian job offer at this time. So in second part, we'll only talk about Federal Skilled Workers class. There's another class called Canadian Experience class. We are omitting that class for today's meeting, but we would definitely schedule something if there's an interest in one of the later sessions. In third part of the presentation, we'll just touch upon the Canadian Experience class and then move on to question and answer. In this session, at the end, almost near the end, before the Q&A session, we'll have, we'll talk about a couple of most important things. Like first class is those mistakes which generally we see in our practice, and those mistakes which must be avoided to make your federal skilled worker application successful. In second part, we will talk about what could be different strategies through which the people or the federal skilled worker applicants or aspirants who are unable to make it because of low CRS scores, what different strategies could they opt for to become successful. So we'll look at those strategies. I once again disclaim that naturally in this brief presentation and in this brief session, we cannot cover everything, and anything discussed during this information is for general purposes, and you should ensure that you're not 100% relying on all the information being provided in this presentation to take an immigration decision. But naturally, once you sign up and we have seen your documentation, the evidence closely, we could always suggest what is the best way forward for you. I don't want people to waste time in a futile exercise. I've seen in my career that there are people who are in false belief that they would be able to come to Canada through federal skilled workers, though they have very low score. Immigration law is very clear. It's black and white. Every day there are new developments. As a part of Ontario Bar Association, I get the opportunity to look at the policy developments very closely. And if you meet a professional and you come to know about a program or your opportunity or your chances of getting in, and they are high, you may be able to immigrate within a year or so. And in other cases, you may, if your profile is not strong enough, you cannot strategize, then there's a possibility that you would keep on submitting your expressions of interest year over year, but you would unfortunately not be successful. So in that case, you may have to look at other options which could be available in your situation. Now, without further wasting any time, which I know it's very precious for you, in a few parts of the world, it would be a late night hour. So we'll just jump into the express entry process, and we'll take it from there. Now, in Canada, coming to Canada, one may be able to come to Canada.
Sajjad, can I hold?
Yeah.
Because because Gia doesn't have the access, can you check whether there's a participant in?
Yes, I'm letting them in by time
Okay,
as I see
right.
them.
Okay,
As
okay.
soon as
Thank
it
you.
pops up on my screen, I'm doing it.
Okay,
Now,
sorry.
yes, thank you, Georgina. Now, coming to Canada, there are more than, as I talked to you earlier, that there are more than 100 ways of coming to Canada. It may include temporary basis, coming to Canada on temporary basis, or it may include coming to Canada on a permanent basis. Express entry is a system of intake, or a system which takes in or which processes applications of certain people. There are three major classes which are whose applications are processed through express entry system. First is federal skilled workers, those international professionals who have a minimum of a graduate degree, which is equivalent to Canadian degree. They have at least 1 year of experience. They have a high to decent English or French proficiency skills. They are adaptable. Their spouses are educated. They may have job offer from Canada. So all those participants, depending on their age, education, experience, adaptability, job offer, language proficiency, they are able to apply. And express entry is the system which allows those participants to come to Canada and to have their applications processed. Now, there is another class called Canadian Experience class. These are generally those people who have been in Canada, who have worked in Canada, and they could also apply under the express entry system. There is a third class of applications which is processed through express entry. They are called federal trade workers, and these people are generally, they have gone to trade schools. They may have a couple of years of trade experience and qualification and certification experience, and based on some modest English proficiency or French proficiency skills, they could also come. So in this meeting, we are focused mostly on the federal skilled workers program, and we'll keep the federal skills trade or a Canadian experience class for another session or another webinar. Now, express entry is understood abroad as a system of immigration processing. This is the management system which processes these applications. This is computer-based. You or your lawyer can do everything on computer without any paper application. So all the federal skilled workers who are eligible, they may be able to apply for Canadian immigration under express entry system. Now, how it works, who is eligible, and who could qualify for federal skilled workers program. Now, we have to keep in mind there are a couple of systems, ranking systems, through which we evaluate whether a person would be able to meet minimum eligibility requirements, or if that person has met minimum eligibility requirements and submits an expression of interest, then that person may also be able to file his or her complete immigration application, the PR application. So in first part, anybody who has an accreditation, educational accreditation, which is called Educational Credential Assessment, ECA, from one of the designated bodies, if that person has got ECA done and that person has written IELTS or other English or French proficiency test within a period of 2 years, that person may be able to make an assessment of whether that person would meet minimum eligibility requirements or not. There's a 67 points grid based on which, first of all, with your IELTS and ECA, you assess whether you would be able to meet that 67 points threshold. If you are able to meet that threshold, then you submit your expression of interest. This invitation of permanent residence application is always through and is always after you have submitted your EOI, and it's always after this is no automatic application. This is not that you submit an application first and then you are able to be processed as a PR applicant. You have to submit an EOI based on your educational credential assessment and English or French proficiency examination, a recent one within 2 years. And if you meet 67 points grid, you are able to submit your expression of interest. Then all the people who have submitted their EOIs, they go to a pool, and the government keeps drawing out of those pools a couple of draws every month. Then the top scoring candidates, they are invited to formally submit their permanent residence applications. So all those lucky ones who are invited every month or depending on the intervals of between draw, they then submit their formal electronic PR applications, which are processed depending on the country or the consulate where you belong to. And the processing times in 80% of the times it is done within 6 months' time. So how it works, you have to answer a few questions to see whether you meet the minimum eligibility requirements. Then we help you assess what your credentials are and how would they be ranked in that system. Once you do, once you have met you feel that you have met 67 points threshold, you have evidence, you submit your EOI, then you're selected in the pool, you receive an invitation, and after the invitation, you apply for electronic permanent residence application, and if successful, you become a permanent resident of Canada. Now, there's a long list of documents which are required for these applications. We're just keeping in, just telling you a few applications or a few documents. I'm just trying to point out that naturally you need to have a valid passport. You need to have your language proficiency tests, which are less than 2 years, and they have the score, the desired score, which in your circumstances would be required for this. And if it is a case that you do not have a Canadian qualification or education, you need to provide the educational credential assessment report to establish your educational credentials. If you have also a run process after EI side-by-side UI side-by-side with a province and you have been selected, you need to provide that provincial nomination. If you've got a job offer, or if you already have it, or you got it during the process, you need to provide that as well. And you have to establish the onus is on the applicant to establish eligibility for this class. Now, we talked about express entry pool, and express entry pool is the one where all the participants who have submitted EOIs, their profiles exist, and Comet keeps on drawing out of those profiles based on the comprehensive ranking system. One thing, as in this particular webinar, we are joining from different parts of the world. We speak different languages. We are in various continents. So there's a possibility that your basic education or educational experience and other documents may not be in English or French, which are two official languages. So in that case, you have to be prepared that everything which is not in English or French, every document, every piece of evidence has to be translated to the official languages in Canada. The fees, they also depend for expression of interest. The first part where federal skilled worker applicants or aspirants, they submit their EOIs. There's no fee for the EOI. There's no government processing fee for the EOI submission. Once you have submitted, you are in the pool and you are invited to apply. Then once you submit your application, there are various processing fees involved, or when you're close to becoming a PR, then there are right of permanent residence fee, and then the fee varies for adults and children. So those fees we can talk about once you have reached that stage. Okay, now after the fee, you have to keep in mind that nobody admits a foreign national in Canada unless Canadian government has satisfied itself through background checks, through medical examination, through criminal background checks that yes, you meet all the eligibility factors, but there is some, they also want to ensure that there is no criminal background or there is no medical inadmissibility which could cause a burden on the Canadian social welfare or health system. So in this process, you have to keep in mind that though you would be able to meet the merit of these applications, even if you're able to meet the merit, but there is some kind of criminal inadmissibility involved, or there is some recent conviction, or you have a criminal background, which reflects that you could be a threat to Canadian peace and Canadian law enforcement system. Then despite having qualified under all categories, despite scoring very high, you may still be inadmissible. So in this process, anybody who's filling out the preliminary information form or the client identification form, if there's anything which concerns you and which you believe might cause an obstacle in your application despite your high merit, you have to mention it to us, and then during consultation we can discuss it. And first, before submitting or before proceeding on your PR application, we must address those concerns and see whether there's a legal way of getting out of that kind of inadmissibility. So we keep on seeing cases We keep on seeing people who are participants of who are citizens of the first world, including US and UK and European countries. They have passports that do not require any temporary resident visas, or they have very high English or French proficiency along with education. They score very high in CRS scores. But even if they have criminal inadmissibility, even a conviction such as driving under the influence of alcohol, despite all the merit, they will not be able to get even a visitor visa, a visitor entry in Canada. They don't require, most of the Western countries, they don't require any, they don't require a visit visa. They may be admitted free without a visit visa, but those people cannot get permanent residence or entry into Canada on a temporary basis, even if they have some kind of criminal issues involved. Now, who are the people we are addressing? Now, at this time during the presentation, we are all clear that I am expecting people listening to this webinar, with those people who are foreign skilled workers who have at least a graduate degree, a minimum bachelor's degree as per Canadian standards in their home countries or from Canada. They have at least 1 year of experience in a skilled trade or profession which is required in Canada. They have high English or French proficiency. Their age is more towards the younger, because there are points allocated for age, education, English proficiency, experience, adaptability. So those people who are in the younger years of life, they score maximum in their age factors. For example, if you are 28, 29 years of age, you may get most of the points in this category. Similarly, those professionals, the highest degrees of those who hold the highest qualifications, the PhD, they get the maximum score. Those who hold bachelor's, they get minimum score in that grade. But those who have a master's degree as per Canadian equivalence or educational system, if it is equivalent to a master's, they are the people who can optimize their scores, because with a master's degree and a high English proficiency, you may also be able to get extra scores for the skill transferability factor. Similarly, for your experience, you gather maximum experience, you may be able to gather maximum points if you have at least 3 years of experience, along with high English or French proficiency, as well as experience. So those people are also the ones who may be able to maximize their score. Now we are talking, and here most of the people should be or would be reaching the target of at least 1 to 3 years of experience, master's degree, English or French proficiency established through a Canadian government's recognized test. If you are married, then the points are also allocated to your spouse's education, experience, language proficiency. If you have family in Canada, if you have brothers, sisters living in Canada, they are Canadians or permanent residents, you may get extra score based on that. If you're a person who has secured during the process, the person who has secured a job offer in Canada, and it's an approved job offer as per Canadian requirements, then that person would also be able to grab extra score in this express entry process, federal skilled workers applications through the express entry system. Processing time, the government of Canada is committed that 80% of the applications which are submitted, 80% of the electronic PR applications after you have been invited and you have submitted the application, those applications are processed in 80% in 6 months' time, 80% of them. A few applications may take a little less than this. Sometimes we have seen applications being processed in 4 months as well. And other applications may take a little longer if there are multiple jurisdictions involved and the government has to go back and do background checks or there are other issues, verification issues. Then it may even go higher than 1 year of period. It also depends. Most of the times there is no interview in these applications. But if there is a reason before the visa officer that this person must be interviewed, to evaluate whether his or her experience is bona fide or whether the experience matches the National Occupational Code, then even in rare circumstances, you may be able to, you may be called for an interview in your respective consulate or embassy abroad. The advantage of this system is that anybody, you don't actually require a job offer for this. You can still qualify without having any connection. If you don't have any brother or sister or close relative in Canada, if you don't have any job offer in Canada, if you don't have any professional connection in Canada, you could still apply under that system, but under this class. But in that case, you have to make sure that you are scoring very high in your language proficiency skills, you have optimum experience, and you have high qualifications. So candidates who are educated enough, who have enough experience, high English proficiency, and a couple of other adaptability factors, they may still be able to immigrate to Canada without having a job offer, or without having a relative in Canada, or without having any kind of a provincial or other connection in Canada. Disadvantage of this application is when people ask that, all right, how much time would it take for me to qualify or come to Canada under this system? We could say it could take 6 months, or it could take forever. So if you are a strong candidate, then you may be able to immigrate under this program, Federal Skilled Workers Program, within months, within 6 months, as the government targets 80% of the times from the submission of your PR. If you are not a strong enough candidate and you don't have strong credentials, your CRS scores are low, then it may take forever, because you would keep on submitting your EOI. EOI expires every year in 12 months time. So you have submitted an EOI, you were not picked up, you never got an ITA, that EOI expires, you come back the next year by submitting another EOI. Your age might have, you're now one year older, and you might have lost some score here as well. So you keep on doing it. That's not the key to success. If you have low score, then you have to, it is advisable that you contact a lawyer, or somebody who could strategize, who is an immigration lawyer as well as a strategist with that kind of thinking. So he could find out a legal way for you to come to Canada by strategizing and choosing a pathway which would have higher certainty for you, or higher probability of success for you. So the disadvantage is, even if you have initiated an application, but your scores are not high enough, you may not be able to qualify despite having met an EOI requirement, the minimum eligibility requirement. So if you meet minimum eligibility requirement, but your CRS scores are low, then you have to think about the legal ways that how could you bump up your CRS scores and make your application more probable for success. Now, the eligibility requirements, we have already talked about them. These 6 factors you have to keep in mind in the grid of this application. So in these applications, your age, your work experience, your education, language proficiency, arranged employment, adaptability, these are the factors which can make or break an application, which could help you secure your Canadian dream, or which could frustrate you that you're not able to come to Canada, even trying several years for this process. Now, yeah, this settlement funds requirement it's an important requirement. You might have heard of it. I especially included it in this application to explain to you that settlement funds are the funds which must be available with an approved applicant, or a participant, or somebody who avails of this program based on his or her family size. So during all this process, if you meet all elements of an application, your EOIs were accepted, you were invited to apply, you submitted, your CRS score was high enough, that's why you were invited. And then in the application process, you were able to establish that whatever you claimed in EOI, on whichever basis you were invited to apply, you have the documentation and evidence to prove those credentials. Even if you are able to meet all requirements, but you do not have enough settlement funds in your account, you would still not be able to succeed in this process, and your application would be unfortunately refused. Now, one misconception about these funds is that once people submit their applications, the electronic applications, they have funds lying in their account depending on their family size. As soon as they submit their application, then they start utilizing these funds for other purposes. And later on, to their surprise, in 6 months or 5 months or 1 year's time, when their application is finally processed and the officer is making a determination, and the officer has reason to believe, or he comes across an evidence that you no more have the settlement funds, even at that stage, your application could be refused. So settlement funds, you should not only have enough settlement funds available as per your family size, but you should also maintain your account till the time that a final decision has been taken. And when you're coming to Canada, landing to Canada, at that time, even the officer, when they are at the port of entry, they're admitting you, they will look at the settlement funds and satisfy themselves that you have enough of it. So in the Federal Skilled Workers Program, there are three skill types. Like skill type O is management level jobs, skill level A is professional jobs, and skill level B is technical jobs and skilled trades. So if you meet all the factors, then we have to make sure that you qualify under one of the national occupational codes, and you belong to a profession, you have experience in a profession which is required by the Canadian immigration in that particular time or in that particular year. Federal skilled trades class, we are not diving deep into this because this is a part of express entry system programs managed through express entry system, but federal skilled trades is for the people who have some trades experience, they have trade certification, they have relatively lower English or French proficiency level, but these are the people who could also avail of the express entry system to come to Canada. Now, Canadian experience, we have already discussed these two classes. We're not getting into detail today, but we have most of our focus on the federal skilled workers class. Now, this is a very important slide, and this talks about the common pitfalls of the federal skilled workers applications. Now, there are so many reasons. I could not, I could not summarize all the reasons here because there are, I think they may run in dozens if we try to look at all of them at one glance. But a few common pitfalls for the federal skilled workers applications are that one, the people are not able to determine their minimum eligibility when they are starting that application. So what happens, they have not calculated it well, and based on some misunderstanding, because you're not submitting a lot of evidence at this stage. You make a calculation, you try to submit your 67 points to your EOI based on minimum eligibility points, and later on you realize that the calculation was not correct. Naturally, the process won't go forward from there. Then when you're submitting an EOI, I have commonly seen that people look at the knock codes, and then when they are matching or when they're picking up the code which matches their experience very close, they add in that, and they, without relying, just they look at the code, a couple of words used in the code, and then they when they are picking up the code, they feel that yeah, my job description or the work which I'm doing, it closely relates to that. Right? It is not closely related to that. Now, this aspect is very important. If you have picked up a wrong code in your expression of interest, or if you have made any other errors in your expression of interest, your application is bound to fail. So we have noticed that even in these applications at advanced stages, sometimes the immigration authorities, they call you for interview based on the fact. I would request our younger participant that his attendee could mute. Thank you very much. All right, now in this expression of interest, if the knock code is not correct, then they may call you for interview, and during that interview, they will have a very, very thorough discussion with you, and they would try to assess whether you have performed the duties which you are claiming in the knock code. So in last year, we had a client interviewed for 1.5 hours only based on that. That client was residing in a country where the consulate didn't exist, so he had to travel to another country, another consulate in another location, and he was interviewed only for the job description and the knock code, and then they finally determined that, look, you do not meet these knock code requirements, and your experience is not what you have suggested, an experience which meets the knock code requirements. So there were some mistakes committed by the visa officers in that particular interview, and they were not doing it professionally. There was an incorrect understanding. So we later on clarified that understanding to extra submissions, and then ultimately that client is today a Canadian permanent resident, but it happens. So these knock codes, job descriptions, you have to match them very closely in both the knock code as well as your job description. If there are errors in it, despite the fact that you met all other elements, you may still not be able to immigrate to Canada or succeed in an application. Then there are incorrect understanding of comprehensive ranking system. People go on the online calculators, try to calculate it there, ask a friend or a family member who did it. They try to simulate their experience, and misunderstanding of the comprehensive ranking system is something which can also be a recipe to disaster. Now, these comprehensive ranking systems, they are managed through the ministerial instructions. When we are looking at the comprehensive ranking system and we are calculating these scores, we go to the ministerial instruction, those notices which are issued by the Minister of Immigration, and then they have set out all different scoring patterns in that, or what should be, how a person should be scored. So if there's an incorrect understanding of comprehensive ranking system, you may be under a misunderstanding that I have high enough score in the CRS and I could still I would be able to immigrate, but you may not be scoring that high in that. Then the burden in these applications is on the applicant to establish all their credentials. Like establishing age is not a complex thing, like you provide your valid passport and other IDs and your age is established. But establishing your experience in a particular knock code, establishing that that was a full-time experience and you were paid for that, and your company is able to vouch for that experience and certify that experience, that's very important, especially for the people who are not working in multinational or high-end corporations, because those people are the ones, now, those people are the ones who are not working in an organized, not all of us are working in Unilever or Philip Morris or Reckitt and Keyser and other companies. Now, these people, those people who are working in smaller companies, local companies, in their own family businesses, they are looked at very closely, because there could be an element of misrepresentation there, or there could be an element of maneuvering there. So that's assumed or presumed maneuvering by the immigration officers. So you have to understand these requirements. Now the burden is on the officer. The officer would give you an opportunity in the application and in rare cases in an interview, but it is the applicant who must establish all those credentials. If you somehow, based on misunderstanding or not pleading very diligently, you're not able to convince the officer, then naturally you have not met the burden of proof in that case, and the application may lead to refusal at some stage. Now, similarly, misunderstanding of settlement funds, we've already discussed. There are inadmissibility issues that we have touched upon them previously, and we could tell further that anybody who meets all the requirements or is the highest scoring candidate, if there are criminal inadmissibility, medical inadmissibility, inadmissibility based on misrepresentation, inadmissibility based on some other security grounds or human rights violations and other reasons, that person could still, despite having met all the elements in the Federal Skilled Worker Program application, may still not be able to qualify and could be refused to be immigrated or to be issued a permanent residence of Canada. So if there are some reasons, it's a good idea to talk to your lawyer, to explain everything to them, and then address those issues before you start with your application. Misrepresentation scenarios, I would just give you a couple of examples. Sometimes you are applying for a visitor visa to Canada, or you are coming on a study permit. You have submitted application to Canadian authorities for your previous education, your work experience, and other issues. Now, this application would remain in the database for a long period of time. Now, later on, you submitted or you were even refused an application. Later on, you applied for permanent residence based on the Federal Skilled Workers category, and you submitted an information which was contrary or which was in conflict with the information you previously submitted in a previous application. Now, based on that, you may be able, you may be slapped with, I'm sorry to use this word, with the misrepresentation ban. So if your application in the past carried an information which was in contradiction with your current application, you may be barred from entering Canada temporarily or permanently for a period of 5 years. So it's very important that you keep all the information consistent during this process. Now, we have seen there's a question in a few of you who might have applied for a temporary resident visa, or someone in their family has applied. They may be aware there's a question in those forms that have you ever been refused visa or entry into the US, into Canada or any other countries. So sometimes people just look at the application, and then if they have never been refused visa of Canada, they answer no, though they might have been refused a visa for Europe or UK or another country. So when the immigration has that information, has this means to verify that information, and they feel that you didn't correctly answer, we have seen cases slapped with the misrepresentation ban for a 5 year period. So unfortunately, even if that person has got enough of score, the CRS scores and eligibility factors and everything, if there's some misrepresentation involved even on such a minor issue, then one may not be able to come to Canada or even apply for permanent residence or any other kind of temporary residence for a period of at least 5 years. Now, in the last slide, which I was very excited to share with you, it talks about the people who have evaluated themselves and they feel that their scores are lower than what could probably select them in the express entry system. What are various things they are able to do to enhance or to bump up their scores? There are multiple things which they could do, and those things we could cover in a later session as well. But a few common things which one could do to bump up scores are one, secure a Canadian job offer. Secure a Canadian job offer, talk to employers in Canada, talk to headhunters in Canada, talk to your friends and family in Canada who are able to connect you with a genuine employer in Canada. You don't have to pay. I am aware that there are scams all around the world, that there are agents and unscrupulous elements, consultants who tell you that, all right, pay us $30,000, $20,000, $40,000. We can arrange a job for you. Please don't fall to those kind of tempting offers from these consultants. This is a crime. If you are involved in maneuvering a job offer, you have no intent of actually working, and a Canadian employer only shows on paper that you have a job, then likely that person is not only violating immigration law, but also criminal law in Canada, and there could be criminal consequences. But for genuine job offers, there's no bar. You can go to your relatives, friends, you can approach employers directly and try to secure a job offer. Now, this job offer, not only, it's not a job offer on a piece of paper that you are offered this job and this is your salary. This should be a job offer which is approved by the Canadian government. You cannot just have a job offer letter and based on that get those scores, but actually your employer has to go to the Service Canada or Employment and Social Development Canada. Your employer has to establish that he or she has or it has tried to hire Canadians or permanent residents who are available to take up the job, but he wasn't able to get any appropriate candidates, and there were recorded reasons that he was not able to secure those resumes or those. In that case, that employer is allowed to hire a foreign national. So approved job offer, a job offer by a Canadian employer who has gone to the government and got an approval that since he or she is not finding a Canadian resident or a citizen, he is inclined to hire a foreign worker. So that job offer may get you points from 50 to 200, depending on the level of that job offer. If it is a management level job, then you can expect to get an extra 200 points. So someone who is sitting at 350 CRS scores, if he gets a job 00 knock and approved employer, that job could get you around 200 points, and then that would make journey of immigrating to Canada a breeze for you. Similarly, if you don't have an employer in Canada whom you know, if there's no relative who could connect you to a genuine employer if you couldn't get a job offer, or if there's an employer who's willing to offer you a job, but that employer is not willing to go to Service Canada and do all the application process to get it approved, and you are a person who may be able to establish a business in Canada, you have some funds available. At this time, there's a program available in which there's an option available or a route available that you look for a business in Canada through a lawyer, through a business lawyer or an immigration lawyer, and that you secure that business. So you buy a majority shareholding of that business. Now, based on that business, you apply for a work permit, you come to Canada, you establish yourself here, you do the job for a year or so, and then later on, you, in another application, you claim the 200 points which are allocated for, if it is a 00 job, then you can grab those points and it could bump up your score. Similarly, you could do it while being there, but in this case, it's important that you have some investment available through which you can buy your own business. And for operating that business, for the sake of operating that business, you come to Canada on a work permit, and or you could grab or claim extra points in your CRS score. Similarly, people, most of the times, they believe that they have to meet minimum English proficiency or French proficiency score. For example, the minimum requirement is CLB 7 for English, which means that you have to secure a band of 6 across all factors, including listening, speaking, writing, and all 4 factors. Now, that's the minimum. That may qualify you to enter the EUI pool, but depending on other factors, if you are able to maximize your score, English or French proficiency score, then your chances enhance. If you have CLB 7, you may not be able to get extra points for skill transferability or your educational transferability. If you have CLB 9, which means 8 in listening and 7 in all 3 factors, then you may be able to get extra points, not only for your higher English proficiency, but for skill transferability as well. So if you are a person whose English skills or French skills are lower, then it's important that you improve your scores. Similarly, if you are a person who is proficient in one language, for example, English or French, and you are willing and able to learn the second language to a decent level, not a very high level, even that would help you bump up your scores. Education, if it is feasible for you or if it fits into your plans, yes. If you're a bachelor's degree holder, naturally a master's degree holder would get higher score. Now, when we are at the strategizing phase or stage, then we look at all the factors and see where are the low-hanging fruits and how can we maximize your CRS points, and then we can create a strategy which is for you. Naturally, you have to be very practical. You don't want to get into a strategy in which you are spending years and years and you are losing points in the age factor. Now, Canadian education and work experience, though strictly it falls under the Canadian experience class, but if you are able to come to Canada or work here, naturally you'll transition yourself from federal skilled workers to Canadian experience class. And currently the government has focusing more towards the people who are already in Canada and who have some kind of Canadian skills or education or experience, as they believe that the person who is already in Canada, he's now more adaptable to become a Canadian citizen. So if the strategy or your circumstances permit, it could be one option. Securing a provincial nomination. Securing a provincial nomination means that you are able to go to a province which has labor shortages, and you run a parallel application process there. And if you qualify, then the province nominates you and you get extra 600 points for this. Now, one major misconception is that the people who have you might have heard about the provincial nomination, skilled nomination program, but most of you may not be aware that around 80 to 90% of these programs, they favor the people who are already in Canada. 2 to 3 programs may be open to the people who have never been in Canada, but then the competition is fierce. Now, if you are someone who has lived in that particular province, or he has done a job, or he has a job offer from that province, that may be able to secure higher points. But if you are someone who has never been in Canada, who has no job offer from a particular province, it may become a difficult task to secure a PNP application. But reviewing your profile, having looked at your knock codes, your scores, would give us some idea that there are 1, 2, or 3 provinces in which you could try your luck. And we have seen various multiple low scoring CRS scoring candidates who were able to secure nominations in smaller provinces, and based on that, they were able to come to Canada. Now, similarly, securing temporary residence with dual intent leading to a PR, a permanent residence pathway. If you are coming to Canada on a temporary basis, you must establish in your application that you would only be in Canada for a temporary period of time, and you would leave Canada. So if the officer believes that your intent is permanent, then even despite having a visa, you may be refused refuse entry into Canada. Now, there's a concept called dual intent, in which you are coming on a temporary basis, but you also may possess a permanent intent. So in those cases, there are certain ways in which the scores could be bumped up. There are other options. A few of you who might be working as executives or managers in business, they may be able to come to Canada through one of the entrepreneur pathways. Sometimes it happens, we see candidates, brilliant candidates, very highly educated, highly experienced, but they are in an age bracket like 45 and above, where they won't be able to maximize their CRS scores. But these are the people who have some kind of business experience, managing business experience, management of business experience, and business development, other skills which are required. So those people may also or do look at the entrepreneur options available to them. Similarly, startup visa is another option. We'll come to this program. It requires a full-fledged webinar or a session, but there are startup visa options if you are an innovative entrepreneur and you are somebody who has worked in a business environment and you have some innovative idea. You may be able to approach Canadian companies, startups, incubators, or angel investors, venture capitals, and get nominated, based on which you could get immigration. Now, I think there are still many options left, but these are the major ones, and then there are unique options once we receive your resumes or your preliminary information. We can look at specifics of those programs and how would it interact vis-a-vis your profile. So what we covered today, we covered federal skilled workers, and most importantly, some basic steps or elements of those applications, and then the major pitfalls of these applications, and what are the ways to bump up score. There are several things left out. Naturally, we couldn't cover it. We have already run over the presentation time, but I wanted to give you maximum information which I could. The next steps is, how do you start the process? So if you believe that you wish to wish us to look at your profiles, just a preliminary review, you can fill out these 2 forms, which would be circulated to you. This presentation would be circulated to you. You could just click on these forms and fill out information. And once we review that information, someone from my law firm, after I've reviewed, would get back to you with our initial feedback. Now, anybody who has been able to join us or remain with us till this time in the application, normally we charge a $375 assessment fee. But for the first 3 aspirants or applicants who would submit these forms to us, we would not only make an assessment of their profiles, but we would also schedule free consultation with those people in the coming days. So this is what we could offer to help you, a few of you at least, to